Now, there's another really important issue that came up in Ross's appeal and in the ruling, which is that the government obtained pen trap orders without a warrant, without probable cause, to monitor IP traffic to and from Ross's devices. And the defense argued that they needed to get a warrant to do this. And Judge Lynch, in his ruling, rejected that, relying on a precedent from the Supreme Court decision of Smith versus Maryland, which has been labeled the Third Party Doctrine, because the Third Party Doctrine says that you don't have any privacy protection for information known or exposed to third parties, for instance, an internet provider or a phone company, that's open season, that is not protected by the Fourth Amendment. Now, it was a decision made in 1979, which is almost 7 decades ago, based on this technology. It's very controversial because it's limited the scope of the Fourth Amendment in the digital age. According to many legal scholars, it was based on the fact that at the time, when you dial a phone number, that phone number is not private. And even then, 3 judges dissented from the opinion and said, yeah, you still have a right to privacy of what numbers you dial. And Judge Potter Stewart wrote that phone numbers were an integral part of a communication and part of the content of the communication, and so you have a right to have it be private. So, of course, now we're not talking about dialed phone numbers. I remember dialing phone numbers. A lot has changed, believe me. So now we're talking about endless amounts of data. We're talking about financial and credit card records, medical records, photos, documents and file sharing on the cloud, location information, browsing activity, emails, what we watch, what we post, what we buy, what we research, who we date. All of that information is available without a warrant because of the Third Party Doctrine. So why does the government even need a warrant to go in your house? They can find out a whole lot more from third parties about you, very personal, very relevant information, without a warrant, without probable cause. And it's really one of the main reasons that the Fourth Amendment has lost its relevance in the digital age. So under it, there's nothing to require any oversight or limitation on government surveillance. It's basically open season, that. Now, the courts have been reconsidering this and saying that, we're going to rethink this. And even Sandra Sotomayor, Supreme Court Justice, said it might be necessary to reconsider the Third Party Doctrine because it's ill-suited to the digital age. Basically, the courts are trying to apply 20th century law to the 21st century, and it's just not fitting in general. It doesn't fit in the Silk Road case specifically, and it doesn't fit in general in the digital world. So Judge Lynch made the statement. He said, well, whatever, we remain bound by that rule, the Third Party Doctrine, and unless it's overruled by the Supreme Court. So I'm hoping maybe Ross's case can make that happen. And because the Third Party Doctrine needs to go the way of the dial telephone.